Good afternoon. My name is Blair Kelly. I'm a historian of movements, and I'm really excited to be here today to talk to these activists, attorneys who symbolize a lot of what the movement has gleaned from the 14th Amendment. So I think this is going to be a really exciting panel. Deb Ellis is the founder and consultant of End the Pay Gap. Ms. Ellis is a former adjunct professor of sex discrimination law at NYU's School of Law and has served as staff attorney at the ACLU Women's Rights Project and as legal director at NOW Legal Defense and Education Fund. Nikki Shute is partner at Burnett Shute Daniel of Columbia, South Carolina. Ms. Shute is an attorney specializing in gender, sexuality, disability, race, and the law. She has played an active role in the LGBTQIA movement for civil rights. Louis Steele is senior counsel at Golden LLP, New York, New York. Mr. Steele began his work as a civil rights lawyer in 1964 when he joined Robert L. Carter's famed legal team at the NAACP. He has worked on a broad range of cases, including discrimination in employment, housing, and criminal justice. I was just chatting with him about being an observer at Attica. His autobiography, The Butler's Child, chronicles his life and his work, and we're excited to have them all here. If you'd like to start.
Okay, great. I'll grab that mic.
So good afternoon, everyone. I'm so happy to be here, and I want to thank Historic Columbia and USC and everyone else who worked to make this day happen. It's a very special day. I met Pat Sullivan more than 30 years ago when I lived and worked in Montgomery, Alabama, and it's great that Pat collects such a great diversity of friends and keeps them. So as we have heard since yesterday evening, the 14th Amendment is incredibly broad, and even with all the different panelists we are listening to, we're only touching on its breadth in this time. So during my time today, I'm going to focus on the significance to the rights of women and their legal equality of the 14th Amendment, both historically, today, and in the future. When I say women, I want to recognize that gender discrimination has an even greater impact on women of color, who suffer the intersectionality of both racism and sexism. For example, in the pay gap, the issue I'm working on now, the gap is significantly greater for women of color. They earn 68 cents to every dollar that a white man earns, and a white woman earns 82 cents to every dollar. My thesis is that the 14th Amendment presents an ideal that has only begun to be realized in the intervening 150 years through court cases, state and federal legislation, and ordinary people exercising their citizenship in the streets, in boycotts, in hunger strikes, in voting, and running for office. My thesis, which I did write before this morning, turns out to be pretty similar to the conclusion of the morning's panel that Randall Kennedy summarized as the 14th Amendment was an advance, but it was limited. Why has it been so difficult? Why has it been so limited? Well, another part of my thinking is that it involves power. All these issues involve power, and people who are in power do not want to give up their power. And so I do think it's an interplay, going back to the discussion this morning, between lawyers and people and legislatures, everyone working together. So for women, the 14th Amendment, was enacted in 1868, as we know, when women had a decidedly second-class status under the British common law. Married women were especially second class because they lost all their legal rights when they married under the doctrine of coverture. Their legal identity was literally covered by the identity of their husbands, and they lost whatever ability they had to contract or be sued. This is white women who had those rights. But it's taken more than the 14th Amendment for women to secure rights. and we still have a long way to go. I will address just 3 areas today. I can't do everything: citizenship, employment, and reproductive justice. First, citizenship. I would say that the vote is the most important citizenship right, and the 14th Amendment didn't help women get the vote. In fact, the 14th Amendment added gender into the United States Constitution by declaring that all male citizens under 21 could vote. And of course, it wasn't until 5 years later when the 15th Amendment was passed, guaranteeing black male citizens the right to vote. Women didn't get the vote, white or black women did not get the vote until 52 years after the 14th Amendment in 1920. Which, by the way, I looked up last night. South Carolina did not ratify it, the 19th Amendment, until 1969. Sorry. The suffrage movement grew out of the abolitionist movement. Many of the same people were active in both. But after the Civil War, there was a split over what to fight for and what to prioritize: the vote for women or the vote for black men. And some suffragettes engaged in racist tactics, saying it was better to have white women be able to vote than black men. After the 15th Amendment passed in 1870, guaranteeing black men the vote, Frederick Douglass tried to heal the wounds that had been caused by the split. And he remained an advocate for women's suffrage until his death in 1895. So women fighting for suffrage did try to use the 14th Amendment. In 1874, Virginia Minor in Missouri tried to use the Privilege and Immunities Clause of the 14th Amendment to say that Missouri was denying her constitutional right to vote. But the Missouri courts and the United States Supreme Court found that voting is not a privilege of citizenship. Okay, so the 14th Amendment didn't work there. Suffrage did finally succeed in 1920 when, as historian Nancy Cott says, it finally commanded a mass movement of women across race and class for the decade from 1910 to 1920. There were a lot of divisions in the women's movement fighting for the right to vote, but in that decade, people really came together. They used great organizing tactics, marches, and even hunger strikes. Sometimes I think we forget how hard any change is. The New York Times even opposed suffrage. I was shocked to find that out recently. It was signed into law by Woodrow Wilson, who lived in South Carolina for a few years and whose home you can visit here in Columbia. So looking more broadly to other citizenship rights, it was not until the 1970s, almost more than 100 years after the 14th Amendment was enacted, that the Supreme Court used it to give women more rights. In 1971, the courts took down an Idaho state law saying it was arbitrary gender discrimination to automatically favor men over women in administering probate. The case was called Reed versus Reed, and Ruth Bader Ginsburg wrote the brief for the plaintiffs. In Reed and subsequent cases in the 1970s, Ruth Bader Ginsburg and other women's advocates like Pauli Murray hoped to have the court say that all sex classifications, like race classifications, had to be judged by a strict legal standard we call strict scrutiny. In 1973, the Supreme Court rejected that argument, in part because the Equal Rights Amendment was pending, and instead articulated a lesser standard, the intermediate standard. Under the intermediate standard, some laws based on sex have been struck down and some have been upheld, especially if there was a biological difference between men and women. One of the most significant cases for citizenship rights, in my opinion, is the male-only draft, which was upheld in 1981 in a case called Rosco versus Goldberg. Why do I think that's so important? Well, the inability of women to fight in the military was one of the reasons, if you look back in the history of the anti-suffrage people, for denying women the right to vote. And much as I don't like the draft, I think women should have the same responsibilities as men, and thus should have to register. It's not true that my young adult son has to register for the draft and my young adult daughter does not. With women in combat now, perhaps that question will be revisited at some time. And the combat exclusion, which was the rationale for the decision in Rosco, has, as we've seen, changed slowly and gradually, not through court decision, but through decisions of women by military leaders mostly. Finishing up citizenship, the 2016 election is inspiring women now, this year, to exercise their citizenship rights as never before. 309 women are running for Congress in the fall elections. Turning to employment. We all spend the greatest percentage of our waking hours at work. So I think employment is huge. But the 14th Amendment has had limited utility here because, one, it only applies to action by the government, as Randall Kennedy talked about last night. And two, it requires intentional discrimination, which I know one of my panelists is going to talk about later. It was first used in employment. A woman named Myra Bradwell tried to challenge an 1873 an Illinois law that prohibited women from being lawyers. Do you think the Supreme Court found in her favor? No. It turns out that that's also not a privilege and immunity. She used the privilege and immunity clause of the 14th Amendment, but the court said that there was no constitutional right for women to be able to get a license to practice law. Instead, they said, quoting, "The paramount destiny and mission of women are to fulfill the noble and benign office of wife and mother." Okay, let's jump forward 100 years to 1974, when you could use the Constitution to try to challenge employment-related practices of state governments, right? That would be the state action. But this case, in Goldberg versus Aiello, the plaintiff challenged a denial of disability benefits when she took a pregnancy leave. And the court said that she would not win under the 14th Amendment. It was clear sex discrimination, or it wasn't. They said pregnancy is not sex discrimination. It's discrimination between pregnant and non-pregnant persons. Now, I've never seen a pregnant person. I've only seen pregnant women. But that case was overturned fairly quickly by Congress in the Pregnancy Discrimination Act. So Goldberg doesn't really have any meaning for most women, but it does show the limitations of the 14th Amendment for women. So most of the progress for women in employment has come not from court decisions interpreting the 14th Amendment, but from federal and state employment laws and decisions interpreting them, such as the 1964 Civil Rights Act, which we've talked a lot about today, the Equal Pay Act, and more recently other laws such as the Family Medical Leave Act. Today we're at a significant cultural moment when I also want to think about how much can law change behavior, the 14th Amendment or any other of these laws. As someone who's worked on a lot of employment discrimination cases, I find it very frustrating that sex harassment has been unlawful for 50 years. How can it still persist so strongly? And why are women still so underpaid? The Equal Pay Act was enacted in 1963. The New York Times published an article recently about the persistence of sexual harassment at the Ford Motor Company, and talked about how Ford had been sued years ago in the 1990s, and it had a federal court order and had monitors and had changed the culture a little bit. And then years passed, new people were hired, they didn't get very good training, and the same thing's going on. So that's one of the questions I'm posing too, is how difficult it is really to change behavior and attitudes. The Me Too and equal pay movements right now, though, are demonstrating and giving me some hope. They're demonstrating that, like the fight for suffrage, as citizens, we need to own our rights. Women are speaking out, collaborating, and working on new efforts, such as banning forced arbitration, which has kept a lot of settlements and cases silent. We can use state legislatures too. I think that's something we haven't focused on enough in the movement, to press for reforms that will gradually go national. For example, in the area I now work in, equal pay, several states have passed laws prohibiting employers from asking applicants their salary history, which can be then used to justify paying women less than men. If enough states pass laws like that, eventually there's a movement to pass a federal law. And we can engage in self-help strategies. I and others are teaching women the strategy of negotiating their salaries in response to economic research by women economists, that women not negotiating salaries is one of the reasons for the pay gap. So the 14th Amendment, again, and all laws are an ideal. Without the interplay of citizen activism and enforcement and continuous enforcement, all of them are meaningless. So now I come to my third topic, where I feel progress has perhaps been the most difficult: reproductive rights. I thought about this issue a lot, because in 1992 I argued a case before the United States Supreme Court. I was more articulate. On abortion clinic violence, actually using the Ku Klux Klan law called Section 1985-3. It's a novel and complicated theory, and we lost. We basically knew we'd lose when they took the case. But we did pass a law called the Freedom of Access to Clinic Entrances Act that did help the issue, not stop it, but at least it prevents large blockades of abortion clinics. So, in reproductive rights, how can women be equal citizens if we cannot control our own bodies? Here's where the 14th Amendment's equal protection of the law, I believe, is most needed. When Roe v. Wade was decided in 1973, the feminist lawyers presenting the case argued both that control over reproductive lives is necessary for women's equality and a privacy theory. But Justice Blackmun chose the privacy theory when he wrote the decision, and this, by the way, was not a unanimous decision and is very contested many years later. Justice Blackmun decided to ground it in privacy, emanating from various parts of the Constitution, such as the Third Amendment against quartering soldiers, and the substantive due process clause of the 14th Amendment. 20 years later, in 1992, Casey reduced the standard for looking at abortion laws, but also came closer to grounding the right in equality, saying that, quote, women's right to control their own bodies is vital if women are to participate equally in the economic and social life of the nation. But since Casey, there have been a series of court decisions narrowing the abortion right, and now it hangs by a thread, or the life of one Supreme Court justice. If Roe is overturned, the legality of abortion will be back in the hands of individual state legislatures. And to come full circle, I believe that we need to start thinking about abortion as a citizenship right. And only then will it be on more solid footing for the next generation. So in conclusion, the 14th Amendment has been an ideal, but it has fallen short for women. 150 years later, it is our challenge and our work to make real the ideals of the 14th Amendment through movement building.
Hello, can everyone hear me all right? I'm sorry to tell you I got braces put on about 7 weeks ago, so I still feel like I've just got a mouthful of rocks. My name is Nikki Shutt. I am not a historian. I am not an academic. I'm not a judge. I'm a lawyer. I'm a gay woman. And I'm a civil rights activist here in South Carolina. And so what I'm going to share with you today is how the civil rights how the 14th Amendment has had an impact on my life and the life of the LGBT community here in South Carolina and just nationally. So Deb just reported out to you about the impact of the 14th Amendment on the women's rights movement. I have a little bit better news for you as far as the LGBT rights movement. So, you know, and it's easy to just kind of compare this a little bit to my personal lifeline. So I am 51, And I graduated from high school in '84. And I was off at college, my second year in college, when the U.S. Supreme Court issued the Bowers versus Hardwick case in 1986. And so as a young adult, I'm seeing the U.S. Supreme Court talk about gay people not having rights, not having equal protection, so that the consenting adults engaging in private relations in their house do not have protection. And so that's the backdrop against which I grew up. I was in college then. I was in a sorority. I fell in love with another sorority member. I was at a private Baptist college in Florida at the time. That didn't work out very well. And so my grandfather was here teaching, and he said, I will buy you a car if you come to South Carolina. And I thought, do I want as a gay person come to South Carolina? Let me think about this. But for a car, okay. And yeah, Grandpa will be right there. So I moved up here, it's been 32 years ago. And what I have found in South Carolina is, you know, we're a small state. We're a very, there's a lot of civility here. And because there's been a lot of adversity, the LGBT community is very bound together by adversity. And during, you know, when the AIDS epidemic started, it was the LGBT community that got together and formed the first AIDS service organizations here in South Carolina. And we had our first Gay Pride March in 1989, so 29 years ago. And it was terrifying, I will tell you. I did the publicity packets back then, and marching down Main Street to the State House, we all thought we were going to die. And that wasn't the last time in a Pride March I thought I was going to die, but you know, I'm happy to say, though, I have had the opportunity as a gay woman and as a lawyer and a civil rights activist to bring all those parts of my life together and to try to serve the community. And the service of the community has been largely as a lawyer using the 14th Amendment to get rights for my community. And so I'm going to tell you a little bit about the story about marriage equality here in South Carolina. And we've got a hero in the room with us. We've got Judge Richard Gergel, who issued the groundbreaking decision, the heroic decision on that. And Judge Gergel, thank you so much. We got to hear from Judge Goldberg earlier, so I'm going to tell you a little bit about that struggle. So, you know, for many years, the gay community, you know, we stand on the shoulders of everyone in this room and everyone who we've talked about the last 2 days who came before us and who lost jobs and who lost their lives and were injured in the movement for equality. For the gay community, you know, really our movement has been about the last 40 years, last 30, 40 years. And the first, I told you about the civil rights, the Bowers versus Hardwick case, 1986. That was actually a Georgia case. And that was the case of a young man who worked in a gay bar, and he was out taking out the trash after the bar had closed that night, and he was holding a beer. And a police officer drove by, saw him with the beer, and didn't like gay people very much, had a bias, and stopped him and hassled him and gave him a ticket for an open container. On the ticket there were 2 court dates, and the young man didn't go to the first court date, thought it was the second court date, and the judge swore out a bench arrest for his arrest, and the officer that had given him the first ticket decided to exercise that arrest warrant, went to his house, went in, knocked on the door, someone else was there, let him in, and burst into his bedroom and found him engaging in private consensual sex with another adult and arrested him for sodomy. That went all the way up to the Supreme Court, and I already told you that despite using the 14th Amendment, the decision was that there was no right for gay people to have that kind of privacy and that kind of protection. So fast forward, and I think it was Dr. Durham earlier who talked about the LGBT rights movement and whether we went for marriage, whether we decided to go for marriage, because we decided that, you know, we too have had a number of campaigns and a number of national strategy meetings and statewide strategy meetings, and marriage wasn't what we were going for, actually. It seemed to be the biggest prize, and it was not something that seemed achievable. It seemed more achievable to get employment non-discrimination. So we started with legislatures. We started with towns. Here in the city of Columbia, Mayor Bob Coble, back in the 80s, added protection for sexual orientation in the employee handbook. When Mayor Steve Benjamin came on board, his group, his city council, they went further and added gender identity and broadened that for protection for accommodations and for contractors and for employment and a wide range of human rights ordinance. But as the 14th Amendment, as the case law developed, ultimately that is the ultimate prize. That is the ultimate civil rights, because there are 1,089 rights you don't get unless you have the title of marriage. You don't get Social Security benefits. If my partner and I die and we're not married, she doesn't get my Social Security benefits. If you die intestate without a will, your partner doesn't get those. Your family gets all of your wealth. Many rights, changing driver's licenses, many things. So ultimately we decided that is what we were seeking. In the fall of 2014, the Fourth Circuit Court of Appeals, which is our appellate federal court that includes South Carolina, issued a favorable decision. And we then wanted to see about folks getting married in South Carolina. There are 46 counties in South Carolina. There are 46 elected probate judges. Judges are actually popularly elected. They have a listserv where they communicate with each other. So the community started reaching out to some of the friendly probate judges and said, basically, if a gay couple comes in, will you marry them? And that reverberated around the state, and everybody was saying, no, don't do it, don't be the first one, don't try it. But we were lucky enough to have a member of our community named Colleen Condon, who served as a county council member in Charleston. And as typical South Carolina, her cousin was the probate judge. So there was a limited window of time where Irv Condon said, Colleen, if you and Nichols come over, I will do this. And the judge was very intentional about it. So the way our law works in South Carolina is we have a cooling off period. If you go in and apply for a marriage license, if the probate judge takes your license and takes your money, then 24 hours later, you have to be issued the license. The judge has to issue the license, because we can't get married right away. We have to stop and think about it, right? But if the judge takes your money and takes the application, there's no discretion. The judge has to give you the license. So what Judge Condon did that day was his cousin Colleen, and her fiance Nichols went to the probate court in the probate court in Charleston County. Judge Condon let them fill out the license, give the money. He immediately called the South Carolina Supreme Court and reported what he had done. Said, I've just done this, so in 24 hours I have to issue a license. Tell me what I should do. Immediately, the Attorney General for South Carolina filed a petition, an emergency petition with the South Carolina Supreme Court, asking the court to stop Judge Condon and to order all the probate judges to stop. At the time, there was pending another case that had been pending for about a year and a half in federal court called the Braddock's case. And it was a nice lesbian couple who had gotten married in another state, and they wanted their marriage recognized here. What we did not have pending was a case like Colleen and Nichols, where they had tried to get married in South Carolina. So we immediately, on behalf of Colleen and Nichols, moved to intervene with the South Carolina Supreme Court, and at the same time file our own lawsuit in federal court. The Supreme Court, so Collins and Nichols applied for their license that morning. That afternoon, the Attorney General filed a petition to stop all same-sex marriage in South Carolina. We moved to intervene that day. The next morning, the Supreme Court met and agreed that we could amend, but said no probate judge could marry anyone, any same-sex couples, until a federal court ruled. At that point, we filed our lawsuit on behalf of Colleen and Nichols against then Governor Haley, and using the 14th Amendment as the basis, and said the state of South Carolina should not prohibit them from getting married, and the state had an obligation to give them their marriage license. When you file a lawsuit in federal court, we've got divisions of federal courts, one federal court in South Carolina, but we have different geographic divisions. We filed in Charleston because that's where the license had been issued. And then it becomes pure luck of the draw what judge gets your matter. And we were lucky enough to get Judge Gergel. And I've never moved so fast in a case. Every deadline we had, Judge Gergel, the regular deadline would be 15 days, he would shorten it to 7. And we had a very expedited schedule, and we filed a lot of motions. And ultimately, Judge Gergel ruled that the 14th Amendment prohibited this type of discrimination, and that Collins and Nichols and everyone else who was interested in the protections of marriage was entitled to that fundamental right. The Attorney General of South Carolina did not give up at that point, though. The Attorney General appealed that to the Fourth Circuit Court of Appeals and asked for an emergency stay. That emergency stay was denied, and then took it to the U.S. Supreme Court. When you take something like that to the U.S. Supreme Court, I actually didn't know this before then, that a justice is assigned to each state, basically. And so if you have some type of emergency writ, one of the justices is already assigned, and our justice was Chief Justice Roberts. And my heart sunk when I saw Chief Justice Roberts, because I thought, he might stop marriage. And he took a few days to decide. It took about 4 days to decide, and I held my breath for that entire time. At that point, though, he said denied. He said the emergency stay is denied. And so at that point, we were still, on appeal, but by that time, Judge Gergel's order now had gone into to be in effect, and that was November of 2014. So I'm happy to report that South Carolina was the 35th state to allow marriage equality in the United States. And to me, you guys, that's a really enormous deal, because this is a state where we pride ourselves on being very last, right? I mean, we're really proud of that. You're not going to make us do it unless you're only a gun to our heads. We're proud of our stubbornness. But the 14th Amendment and the case law, the body of case law, allowed us to have this kind of seismic event, and allowed people, protections. Colleen Nichols, Colleen has a son. It allowed Colleen's son to then have all of the protections that being in a family, being in a couple allowed. If something happened to Nichols, now Colleen's son would be able to get Social Security and all of those protections. So, for the LGBT community, the 14th Amendment has had a huge impact. We're not done yet, though. As we're fond of saying, we can get married on Sunday and fired on Monday. There's no protection that's, clear and uncontestable for employment non-discrimination for LGBT folks. And also our transgender community is very vulnerable now. And that's a very evolving area of the law that, again, the 14th Amendment, we hope, will protect folks. But, we're still waiting on that and still trying to protect a lot of folks. So thank you very much for listening to the story, and I appreciate everyone being here today. I've learned an immense amount.
Hello, my name is Louis Steele. I am a practicing civil rights lawyer, not an academic. And what I'd like to talk to you about today is really what's happened to the 14th Amendment since 1964, when the Civil Rights Act was passed. And I must say, when I've thought about that in terms of this presentation, I had a general idea that civil rights enforcement under the 14th Amendment has become infinitely more difficult over the years. That I really had not put two and two together, two being the 1964 Civil Rights Act and the other two being the 14th Amendment. So what happened in 1964? Civil Rights Act was passed. It created all sorts of rights in terms of rights in people being able to utilize virtually any public accommodation. It contained rights with regard to school segregation, and it opened up, in effect, the whole world to take on and dismantle the Southern Jim Crow apartheid system. And that's slowly what happened. Now, you do have a Supreme Court case that came down in 1964. You've got the Heart of Atlanta case, in which the Supreme Court said, yes, this Civil Rights Act is appropriate under the Commerce Clause, not under the 14th Amendment, but under the Commerce Clause, and shall go right into effect in terms of the time limitations built into the statute. So what happened after that in terms of litigation? A few cases occurred in which the 14th Amendment was a critical ingredient. One is the Loving case, and looking at my little cheat sheet, that's a 1967 case. And in 1969, there was actually a Supreme Court case that I played a role in writing the brief, working for Robert L. Carter at the NAACP, Hunter versus Erickson, in which the Supreme Court ruled 6-3, not 9-0, 6-3, saying that in Ohio, a particular law which required to validate a fair housing law, city fair housing law, there had to be a referendum. So what you had in Hunter was an absolute obvious racial classification. The only laws in the whole state that you had to have this double process, the city had to pass an ordinance, and then the statute which was passed by that ordinance had to survive a referendum. Referendum knocked the statute out. The Ohio Supreme Court ruled 7-0, upholding that process, and we took the case to the Supreme Court and won that case on the 14th Amendment. A clear racial case, no question as to the intent about passing the referendum bill, which created the double system where you had to pass an ordinance in the city and then survive the referendum. So up until that point, 1969, you could see one or two cases emerging out of the Supreme Court where the 14th Amendment was the driving force in creating more equality. What happened after that? After that, you see a series of cases in which the 14th Amendment was not utilized by the Supreme Court. In fact, the Supreme Court said unless you prove actual intent in any of these cases, unless you prove, for example, in a classic case, Milliken, the Detroit school case, unless you prove that these suburbs absolutely intended to create a system whereby whites would migrate into those suburbs, go to the schools in those suburbs, and lock black kids into segregated schools in Detroit. Unless you prove that, you lose the case. And so the case was lost 5-4. Marshall was on the court, he dissented, but think about that in terms of the Brown discussion we had today. 5-4, the 5 had no problem saying, oh boy, let's try and get 6, 7, 8, and 9. No, they had their 5, and they had their precedent, and they had what they wanted. So intent starts to come into the 14th Amendment at that point in time, and you see it over and over and over. And you see other cases where the Supreme Court no longer has a great interest in the 14th Amendment. And so one of those cases you might want to look at would be the Palmer case, in which a town, I believe in Mississippi, closed all of its public swimming pools in order to ensure that there would be no integration in the pools, while a YMCA then opened a large pool, which the town knew was going to happen, and segregated that pool, said it would for whites only. Supreme Court upheld that. So you're now seeing what I view as a counter-revolution. And that counter-revolution went on and on and on and goes on to this day. To this day. And I started trying to figure out, well, I wonder if the passage of the 64 Act might have had something to do with that. And it strikes me when you look at the precedents that occurred, that the Supreme Court said, yeah, come on, why should we be involved in enforcing civil rights? Congress passed a Civil Rights Act that's got a lot of provisions in it, covering public accommodations, covering school segregation. Let people try and enforce their rights under that law. And so what you see is a total withdrawal of civil rights enforcement, really after 1964. And there's a devastating effect to that. So, for example, Milliken and the Detroit case, you end up with massive segregation in an impoverished city, and the whites all going to much better schools, much better financed schools in the suburbs. And you see that in a somewhat different light in the Rodriguez versus San Antonio case, which came down, I think, in 1971, 73, in which, again, 5-4, again with Thurgood Marshall writing a very, very strong dissent. And in the San Antonio case, you're dealing with essentially Latinos who are in very poor schools as compared to white kids in San Antonio much wealthier schools. Basically, the case was a national origin, economic case, an economic case, not a national origin case, although clearly in the background of that case was an absolute understanding that the effect of that segregation was both economic and national origin discrimination. 5-4 again. Majority had no problem saying, oh, we need all 9 votes. This is important. They went right ahead and did it. And that case has resonated in this country ever since, in terms of, you can go to virtually any city in America and you will see the poverty-stricken inner city schools, mostly black and brown, as compared to even in the cities, the white schools in the cities that are much better financed. So you can look at other areas and you see that same problem, the same sense. Oh, 14th Amendment, you've got to prove intent. And then you see cases that say, well, how do you prove intent? Well, you can't just show, the Supreme Court said, you can't just show that the people who either passed the law or implemented some governmental program, you can't just show that they knew that the effect of what they were doing, they absolutely knew it, that the effect of what they were doing was going to segregate kids or harm them in some way. The Supreme Court said, no, you absolutely have to prove intent. That even though they knew what they were doing, they knew the effect of what was going to happen, they absolutely intended that to happen. That's a burden which is almost impossible to prove, because all somebody has to do is come up with some explanation, and a court very easily, not every judge, but a whole lot of judges and a whole lot of Court of Appeals will say, that's another explanation, another reason. Might be sad that all these kids are being segregated or being denied the ability to go to well-financed schools, but that's what the law says. And you see in other areas, you see in affirmative action, the Supreme Court, with Kennedy kind of keeping a tiny window open, Justice Kennedy, relying on Justice Kennedy. It's amazing to having practiced civil rights law in over 50 years and reaching the point where you say, oh my God, if he retires and we get another Gorsuch, if he retires and we get another Gorsuch, for the rest of the lives of most of you in this room, certainly for my life, but hey, give me a break, I've been around a while. But for most of the lives of everyone in this room, if you have Kennedy retiring, which rumors say he's going to do that, and you have Trump appointing the 9th justice, for the rest of your lives, you can write off the 14th Amendment. You can also be aware that affirmative action is going to be off the table. There are a series of cases involving zoning, Arlington Heights being an example of one of the cases where the Supreme Court again said, yes, we understand that if you zone this particular area outside of Chicago and the way you're planning to do it, you're going to create a racially black area and a white area, but you didn't intend to, that wasn't your intent, and therefore go right ahead and do it. You also have a series of set-aside cases. Well, what are set-aside cases? The construction industry, which has very high-paying craft jobs, was and still is traditionally a father-son, maybe a cousin gets thrown in every now and then, or some other relative. Father-son white unions. And so some towns, some cities, progressive cities, came up with the idea, well, we'll have a set-aside. And we'll say that 20% of certain jobs, as long as a contractor is qualified, will go to minorities. Some of them also said go to women. Supreme Court said no, no, no. That's segregation, that's discrimination, pure and simple, and knocked those cases out using the 14th Amendment. Making me kind of thinking that really the 14th Amendment had turned into a white person's amendment. It's a frightening thought. It's a frightening thought that the 14th Amendment passed after the Civil War as part of a package of amendments to free and give to slaves equality could now be turned to do everything possible to keep them from equality. And so you have a case, 2009 case, Ricci versus DiStefano. I often forget that case. But that's one of those cases involving testing. And so in the fire department, you have a test to move somebody up the ladder, and you say, come on, you know, white folks have certain advantages in testing. The kids went to schools that probably taught the English that's going to be used in the test or whatever. And so that advantage is so clear that it's going to lead to segregation in that field. And so even though lower courts ruled in favor of knocking the test out, the Supreme Court said, no, no, perfectly fine, and upheld the test. And I guess that leads me to one other thought, and that's, here we're sitting in this room, we all are interested in civil rights progress. Where do we go from here? And it seems to me that we do a couple things. One, we organize. And that's hard, and that involves putting yourself out there, and that involves taking risks. And on that level, perhaps I could suggests that one of the things you might look at is this reverend from your neighboring state, Reverend Barber, and his Moral Mondays movement. Well, Reverend Barber is starting a new Poor People's Campaign. And the object of that campaign is to really understand that the federal government is not going to be open to any kind of change that has value. And so the campaign is going to be aimed at state governments. And some of the state governments are open to civil rights progress. And what Barber says is he's going to start campaigns. He's allied with a white reverend from New York. They're going to start massive campaigns. They're going to use civil disobedience. I don't know if any of you folks have heard Reverend Barber, but I have, and he really makes me think of Martin Luther King Jr. He has that same sense of organization, of purpose, of being willing to put himself out there. He's a very ill man. He could care less. He's out there every day. You might take a look at what he's up to. I hate to recommend an article of mine, but I'll do that. I wrote an article in a platform called Common Dreams. It's dated April 5, 2018, and it's all about that. It evolves into that movement. It has some history, and part of the history is that the earlier movement, what Barber calls, and I think he's right, the second Reconstruction, which really takes place after World War II, and pretty much up until 1968. What happened in 68, Reverend King's assassinated, Bobby Kennedy's assassinated, Nixon becomes president. There's a Southern strategy. Wallace had come up north, and now Nixon is following in his footsteps. So there's that history in the article, and the sense that for a campaign like this to be workable and continue on, not be a short-term boom, boom, it's over. It's going to take blacks and whites together. And blacks and whites together was my recollection of when I first started working with Robert Carter in the 60s, the early 60s. And that got lost around 1968, and racial progress has really been stagnated since 1968. The question then becomes, can it be brought back to life? That's where we are now. Those of us who have spent our lives doing this work, I must say, are optimistic. If you're not optimistic, you can't do the work. You've got to believe that progress is possible, that we can do it, that it's hard, that it takes risk, but without it, America will never be more than a country with interracial, I hate to use the word warfare, but certainly close to warfare. And we have to repair that. And we can only repair that through massive movement at this point, and through targeting targets where progress is possible. Thank you very much.
So we'd love to open up for questions from the audience.
Not to tout your article too much more, Mr. Steele, but I was not able to write down the name of the magazine.
The platform is called Common Dreams, and if you put that in Google, and either put in my name or Reverend Barber, the article will pop up.
Thank you.
Who is the Reverend in New York?
Maybe it's my age. I block names, and I'm blocking her name, but it's, excuse me, I've got it in the article. I'll give it to you right afterward. She's a well-known pastor, worked organizing the poor, and she should be very effective in this work.
Thank you for the forward vision.
Gotta have a forward vision. You gotta have it.
This is a question, I guess, especially for analysts and any others to comment. This morning, the New York Times editorial board covered the fact that the ERA is bad. I don't know if you saw that.
I did not.
But I didn't know it. And that is, according to this, I guess it's through one house of the Illinois legislature and the other house is going to vote on ratification. And if that happens, it's one state away from ratification. So when you think about the 14th Amendment and your issues and the ERA potential, what do you think about all that? And how do these things, how would that affect your life and the legal strategies involved in these things?
I have thought a lot about the ERA over time. I mostly have thought that it wasn't important enough to spend time on with all the other issues we face. I would probably rather put my effort into the Reverend Barber movement because we all have limited time and effort. I don't think the ERA, I think the ERA is going to be more symbolic, I guess. And as a symbol, I think it's important. So symbols are important. It's going to have the same problem of state action that the 14th Amendment has. If it didn't have that problem, I would be much more enthusiastic. But because it will only apply to government action, that's still limited. On the other hand, I'm going to speak like a law professor here, which I've only been part-time, but I know how to speak like one. On the one hand, on the other hand, it would be important to that to both the points I was talking about in terms of the draft and reproductive rights. So I think if the ERA was passed, there would be a strong argument that women should have all the rights and responsibilities of citizenship that men do, and that women should be, if there's a draft, women should have to register for it and be subjected to it. I also think it would be a way to ground abortion rights in equality in a much stronger way. So I think that would have the most practical impact. And that would be a good one. It would be a good one. Because, you know, we haven't talked really today, we've talked about state legislatures, we also have state constitutions. And our federal constitution, the 14th Amendment, obviously is part of our federal constitution, provides a floor but not a ceiling of our rights. So in some states, not so much South Carolina, But in other states, the state constitutions have given people more individual rights than the federal constitution. So for states like South Carolina where that's not happened, then the Equal Rights Amendment would be an important symbol. So I think it would be an important symbol. It's just a question to me of what else you would not spend time on in order to do that. I personally think that getting out the vote and making sure we all vote is really an important thing to do. I myself and my husband were out there for getting out the vote for Barack Obama in 2008 and 2012, and I did not do it in 2016, and I will never make that mistake again. And I think I always look at the Kantian imperative, like what I'm doing is what everyone's doing, and so everyone should be getting out the vote. We should all be voting because progressives lost an election by very little, right? So we didn't lose, technically. We lost the electoral college. So anyway, that's the question I think is, but I'm thank you. I missed that, and I will definitely go read it. So, other questions? I have a question.
So I have a sense that many in a younger generation are extremely frustrated by the ways in which progress that we've made on our rights vis-a-vis the 14th Amendment in this earlier period and in this later period are easily eroded, are washed away, that we are fighting the same fights in a different generation with new technologies supporting them. So what is your sense of sort of the cyclical nature of what we are facing as we advocate for our rights as citizens?
Who wants to take that? I think it really varies.
You sounded like a law professor then. That's a good law professor. I think if I compare the story that we heard this morning about Judge Wade's Waring and Mr. Elmore and the personal sacrifice the judge went through to the example I gave about marriage equality coming through, I think things are better. I mean, so if you compare Judge Waring maybe getting run out of town on a rail a little bit, and having to move to exile in New York. And then when Judge Gergel issued his decision in the marriage equality case, marriage came in very quietly. And we had, a group of stormtroopers, 50 lawyers and law students all over the state that day when marriage equality came in, and it was 7 months before the nation recognized marriage equality. And we only had one probate judge who gave us any pushback. So, measuring that compared to now, I mean, that shows me that there's progress. But I think that's not judges, lawyers, that's changing hearts and minds. That's the activism part. That is the part that requires voting and requires organizations and requires lobbying at the State House to bridge that gap, I think. So I don't think you can do it all with court cases.
I mean, my view on what I've called stagnation over a 50-year period is that it can be broken. And the way it gets broken essentially is not having lawyers out there doing the job of what citizens should do. We are only effective, as far as I can see, and looking at it historically, when there are real movements that are pushing the agenda. I think Pat Sullivan talked about that this morning. I think that when you look at the NAACP's ability to push what led to Brown versus Board of Education, that was based on massive organization. And so the young people that you're talking about, they're organizing around certain areas. So Black Lives Matter, for example, is a critical ingredient in any massive organization at this point in time. I think the problem will be, which all of the different organizations and different progressive agendas will have to hopefully figure out, is how they can work together. For example, you take a look at somebody like Reverend Barber. He comes from a Southern religious tradition. I'm not quite sure what his view on abortion is.
He's progressive on everything.
But I do know from reading his book, The Third Reconstruction, that part of what has to occur is people have to understand that they can't have everything. They have to try and figure out what it is with other allied groups that they want in common. And those are the areas that they have to move in. So the kids shouldn't be frustrated. You see them out there. You see them out there in the area of gun control.
There's a walkout today, I think.
Oh, is that right?
Columbine.
You see Black Lives Matter. You see the kids wanting to be to energize themselves and be energized. So there is hope, and the kids are part of what should give us all hope.
And to expand just a bit on what I said, it varies, is I am an optimist. Like I really agree with you. I don't think anyone can do this work if you're not in some ways an optimist. So I always think of Martin Luther King Jr.'s line, and I'm a Unitarian, and he was quoting a Unitarian named Theodore Parker. The arc of the moral universe is long, but it bends towards justice. And yes, it just bends. And after the election in 2016, I was thinking it's long, L-O-O-O-N-G, it's long. Because it's sometimes, it's just bending towards justice, not shooting, you know? And I think it's hard, and it's hard for everyone to think of like how cyclical it is, right? And how long it takes. And it is cyclical. I think that as an older person, as my kids would say, an old person. So it's not just the kids that are frustrated. I think we're frustrated too. And we have to all remind ourselves that it takes many people working, and then sometimes that setback, maybe 2016 taught us something. And I see it as energizing a lot of people, young and old alike.
Me too.
Yes, but do you feel that the use of protest is it still what it was? I see a lot of, and hear a lot of pushback about protests and how, oh, it doesn't matter, oh, they're blocking traffic. Oh, you know, there's a lot of dismissiveness when it comes to protests, probably since ever. But, you know, with social media, you hear so much backlash against it. So is protest still a valid form of making things happen in our country? In your
I'll quick and take a stab. I think that it's limited. It draws attention, but it's not the only thing we should do. Like, for example, I'd rather, going to a march is good if it brings attention, but then you got to follow it up with more action, like getting out the vote or running for office or changing legislation.
I agree. I mean, I think, yeah.
I mean, the clear imperative is you can't have a march and everyone goes home tomorrow and it's over. Whatever is done, and Martin Luther King is the classic example. There was no give up until the objective was achieved. And that's true today too. If you have a demonstration and everyone goes home and everyone says, oh, great demonstration, we had a lot of fun out there, or whatever. It's not worth much.
Are you saying, though, that we need a rallying national figure in order to get something done?
I'm not sure. I think it probably helps.
I mean, have we been missing that for a long time?
So I think here of both what Pat said this morning about Charles Hamilton Houston, and given that I have a room full of majority lawyers, I think that Charles Hamilton Houston's model is also an important one, right? So it's not simply that he was taking advantage of existing movement. In some cases, there was no movement in the places he went. He went to see what the conditions are. He went to understand what was going on and to see how he could use his expertise to help. And he built a cadre of like-minded attorneys who were equipped for that fight. And so I know there are many people doing that exciting work, but I don't know if we have enough people, given that we are working in so many sectors of our country right now. Maybe we need more Charles Hamilton Houstons to theorize and push and really know that this fight is quite long. So I think there's really, in many ways, I think sometimes Black Lives Matter is really sort of seen as just their fight, but I don't know who are the attorneys in mass who are behind Black Lives Matter. And I think they need that equipment, that structure supporting them and pushing behind them as well. And the other thing I'd argue is that I don't know that we need a single leader, because if we look at the movement as a whole, King is a wonderful symbol, a wonderful spokesperson for the nation, could always communicate well. My mother always talked about if you put a mic under his mouth, boy, the words are great. But when we look back at movement history, we know that SNCC, we know that Ella Baker, we know that Septima Clark, we know that Jessica Simpson were all part of a larger movement happening in many places and many times. And so as much as it's nice to have a single person, I think that's a limitation. And then we're all waiting for some great person to come. We are that great person, and we all have the duty to do that work, and the movement's in us.
Can I say one more thing that builds on that? The Montgomery bus boycott, having lived in Montgomery and studied it a little bit and known people who were involved in it, I'm always so frustrated that Martin Luther King gets all the credit for it. Who kept that? That boycott went on for a year. There were no cell phones. People had to get to work. It was Black women who organized people to get to their jobs through a huge system of carpooling. It was professors at a college called Alabama State, and they mimeographed like 10,000 mimeographs the night before the boycott started. And they actually did not want their story public because they didn't want to lose their jobs. But it frustrates me that that story isn't out there more, that we either give all the credit to Martin Luther King or the court case, which was important too. Everyone was important. But those women who organized that boycott for a year, that's phenomenal work.
And we forget that the boycott happened also against the streetcars 50 years before. We forget that there were 25 different southern cities with African Americans fighting for their rights against segregation when those laws were passed. And so there's a foundation, there's a groundwork of agitation that's always at play. Even when people forget the obvious parts of it, they remember the bits of it. And that legacy is long.
I think a contemporary model of something that we can look at are the school strikes in the various states. I think that's key in terms of people coming together and mobilizing and then passing that stuff on so it continues.
It's like a wave, isn't
exactly,
it? Yeah.
Exactly.
Yeah.
No, I was just going to say that you still need a symbolic leader regardless. And I think that a lot of people work towards the same end, but Martin Luther King was a pastor of a church, and he did not report to any one person except, his God. And many of the people that we're talking about worked and had to work in order to survive. And so that meant that they did not mind at all sitting back to get better. sitting back to move ahead. And it just happened that at that time, he was the chosen one. So it's not a matter of him being the leader because he wanted to be the leader. He didn't. He ended up in a terrible state of depression because he actually did not want to be, but he was forced to, and he accepted that leadership role. But everybody knew that there were many, many leaders in the movement. And right here in South Carolina, I know she named Tina Poinsett Clark, who I worked with for a while. But there's also the Fleming, young lady named Fleming from Eastover.
Sarah Mae.
Pardon?
Sarah Mae Fleming.
Who refused to get off, to move off of the bus. And she was actually 10 years ahead of Rosa Parks. And so there are many, many leaders that are unidentified. And until we can document all of that information and put it down accurately, we can't put any one person down, but we have to move everybody forward.
I don't know if you're looking for leaders in particular as much as you're looking for instances that promote a person or persons to cause changes to happen in our society. And that's kind of what I think about when she mentioned Sarah Mae Fleming and so many other instances across certainly this state and across the southern part of our country where persons did things to make a change in the history of this country, but only because it happened to them and they had some encouragement behind them to go and do something and take an action or take a stand.
Any other questions?
Thank you. Thank y'all for your wisdom that you shared with us this afternoon, our presenters this afternoon, but I also would like to offer thanks to all the presenters who have been with us today and last night. If y'all would join me in thanking I want to just quickly thank again those who sponsored this program. They're in your programs. They're on panels outside. If you see folks from our sponsors, please reach out and thank them for their support. The evaluations that I left on your table, if you wouldn't mind filling those out and dropping them off at the back, or you can leave them on your table and we'll pick them up as we clean up today. We do have a few books left over. I think those authors who are here would be happy to sign those books if you're interested in that. And the last thing I'm going to mention is Historic Columbia is a membership organization. If you love programs like this and want to see more of them, we would be happy to put more of these on. We would love to have your support in order to do that, and Kelly has some membership forms in the back. Thanks again to Pat and the History Center for partnering with Historic Columbia to make this possible. Y'all have a great weekend, and thank you again.
Thank you, Robert.
The tour is on, so if you signed up for the tour, you will meet